Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In today's episode of the Labour Justice Barometer, we are joined by Marius van Steden, a professor at the Wits School of Law. His research expertise encompasses labour law and employment rights, statutory interpretation, constitutional law and human rights, as well as workplace discrimination, equality, and vulnerable worker and social protection. And his scholarship has significantly contributed to understanding the intersection of labour law with broader socio-legal issues in South Africa. So today he joins Debbie and I to discuss his forthcoming article, Wicked Problems in Labour Law. Drawing on insights from political theory, the article introduces this concept of wicked problems, complex social challenges that involve competing interests, contested definitions, and solutions that often produce new and unintended consequences. Marius, welcome to the Labour Justice Barometer. We are so glad to have you here.
Thank you so very much for having me. It's an absolute pleasure.
So to jump right in, Marius, your article introduces this concept of wicked problems into labour law. Now, for our listeners who may not be familiar with the term, and hopefully once they get their hands on your article, they will be able to dive into it deeper, please can you explain to us what exactly is a wicked problem and why do you think this framework is useful for understanding contemporary labour law?
Yeah, so it is something that may be quite strange for labour lawyers or for lawyers in general, because the term wicked problems actually comes from two urban planners, Urs Rittel and Melville Webber, writing back in the 1970s. So they noticed that certain social problems are fundamentally different from technical problems. Not because they're simply harder, but because they behave differently than other types of problems, right? So think about the difference between a broken pipe and poverty. A plumber can fix a broken pipe. There's a clear problem, a clear solution, and once it's fixed, it's fixed. But poverty, you can throw money at it, you can build schools, you can create job programs, and you can put the best progressive labor law regime in place. And yet it will persist. It shape shifts, and sometimes the interventions themselves create new problems you just simply didn't anticipate. So that, at its core, is what a wicked problem is. It has no clear definition that everybody agrees on, no obvious endpoint, and every attempt to solve it generates ripple effects across the wider social system. Rittel and Webber identified 10 characteristics of wicked problems. Things like the fact that they can't be definitively formulated, that there's no stopping rule for when you've solved them, and that every solution attempt is essentially a one-shot operation with potentially irreversible consequences. And then to your question, why does this matter for labor law? Well, because labor law sits right at the intersection of economics, culture, politics, history, and social values. It doesn't operate in a sealed laboratory. It operates in the messiness of real-world South Africa. And when lawyers and policymakers don't recognize that some workplace problems are wicked rather than tame, they end up applying the wrong tools. They write a new statute, maybe like the new set of amendments we've seen, and expect the problem to disappear. When it doesn't, everyone is baffled. The wicked problem framework gives us a vocabulary and a diagnostic tool for understanding why that happens. And it's a far more honest account of what law can and cannot do.
I really like that analogy of a broken pipe. And I think if we have to actually dive into what you've said about tame and wicked, I think one of the key distinctions that you draw on is this. So could you explain, just in more detail and just looking at this distinction, the difference between tame problems and wicked problems? And maybe you can give our listeners a few examples, as you've already done so far from labor law, where this distinction becomes visible.
Certainly. So I think the best way to think about this is that a tame problem has a right answer. And with that, I don't mean to say that it's an easy answer to find, but it is an answer that we can find. It might just require expertise and careful analysis, but once you find it, the problem is resolved. A wicked problem, by contrast, doesn't even have an agreed upon definition, let alone a single correct answer. So in labor law, tame problems are every day, and they're actually most of what lawyers deal with day to day. If an employer pays workers below the national minimum wage amount, right, then that's a tame problem. You calculate the shortfall, you order back pay, and the problem is solved. If a worker is dismissed without being given a chance to state their case, that's a procedural violation, right? Although there may be some gray area there too. But there's a clear legal standard, an established process at the CCMA or a bargaining council, and a measurable remedy. Or think about, for example, working hours. The Basic Conditions of Employment Act says you can't work someone more than 45 hours a week without overtime pay. An inspector checks the records, finds a violation, and the employer must comply. So these problems have clear formulations, clear stopping rules, and solutions that are objectively right and wrong. But wicked problems look completely different. And I think the most serious one in South Africa's context is, of course, that of transformation in post-apartheid South Africa. What does transformation actually mean? Ask an employer and they might say it's about skills development and merit-based appointments. Ask a trade union and they'll say it's about redressing historical racial exclusion through affirmative action targets. And when you ask government, you'll get a third answer that tries to balance both and often satisfies neither. So there's no single correct formulation of the problem. And every policy intervention, whether it's a new employment equity plan or a sectoral transformation target, generates possibly unintended consequences and new disputes. 30 years into democracy, we're still arguing about what transformation means and whether it's working. So that is a wicked problem.
Thanks, Marius. So coming back to this idea that these are issues, they impact on the labor market and labor concerns, things like structural unemployment, workplace inequality, precarious work, and the inability of traditional legal solutions or tools to address these. Where does this take us in terms of thinking about having our constitutional protections, that sort of basic framework? Is there a suggestion that we recognize wicked problems and deal with them outside of a legal framework? Or is there a suggestion that we recognize them as wicked problems and treat them differently but retain the same or similar protections? I hope I'm asking that in a way that is understood.
Certainly. And I think that really is to the heart of the argument. The Constitution is magnificent. The Labour Relations Act, the Employment Equity Act, the National Minimum Wage Act, all of these instruments are massively progressive instruments and a wonderful achievement for South Africa. But the reason why wicked problems persist, despite strong legal frameworks, is that the law alone cannot restructure the underlying social systems that produce those problems. So you mentioned structural unemployment. South Africa has an unemployment rate of around 33%, but I mean, if you also count in those who have given up looking for work, it rises to over 43%, although, these stats change all the time. The listeners may have to fact check me on this. Now, I mean, the question is that a legal problem? Not really. You can't write a statute that creates jobs. The cause of unemployment in South Africa are tangled up with the spatial legacy of apartheid. Townships built far from economic centers with an education system that still struggles to produce the skills the economy needs. And then there's the added pressure of global shifts in technology that are replacing low-skilled work. And with the sheer inertia of an economy shaped by decades of exclusion, I mean, every proposed solution, labor market, deregulation, industrial policy, skills programs, has its advocates and its critics. And each one generates consequences for the others. That's a classic wicked problem. Or let's think maybe about gender inequality in the workplace. We've got Section 9 of the Constitution. We've got the Employment Equity Act. We've got wonderful codes of good practice. And yet women in South Africa still earn less than men for comparable work and are still underrepresented in senior positions and are still more likely to be penalized for pregnancy. Why? Because the problem isn't just legal. It's cultural, it's structural, it's about who does unpaid care work at home. It's about the kind of jobs that are socially coded as women's work, quote unquote, and therefore underpaid. You can win a discrimination case at the labor court and still not move the needle on the underlying inequality because the problem extends far beyond the boundaries of any particular employment relationship. I think the same is true of precarious work, the rise of the gig economy, labor broking, bogus independent contracting. Every time the legislature closes one loophole, employers find new ways to restructure arrangements to avoid the protection of the Labor Relations Act. That's because the drive towards casualization is rooted in global economic pressures and competitive incentives that operate independently of what particular statutes say. Law is chasing a moving target. But I think, to your point, I want to be clear that my argument is not one of despair. And I do think that recognizing that something is a wicked problem doesn't mean you give up on it. It simply means that we have to change our expectations and our methods for addressing them. And that may have implications for lawyers.
You're listening to the Labour Justice Barometer, and we'll be right back.
So, what are those implications? And, if we recognize laws chasing a moving target, and the issues have cultural and structural dimensions that are way outside of the ability of law, although, we can have an expectation that law is in many ways aspirational, but changes some behavior and has other unintended consequences. But if we bring to the fore and to the front of our consciousness this idea of a wicked problem and, that you have these unintended consequences, whose responsibility, where does to deal with the wicked problems? And I know you've indicated, so I will ask you to follow up on how does that impact on what a labor lawyer would do or what a judge would do and a policymaker. But I'm assuming that when you talk about law, you're also talking about policy. So even if your policy is intended to achieve a certain objective, it's going to come up against a wicked problem complexity that has unintended consequences. How do we deal with this, and how should policymakers approach this?
Yeah, so I think let's break it up. What should lawyers do? What should policymakers do? What should judges do? And then maybe consider what they should do together. I think for lawyers, the most important shift is diagnostic. If you're advising a client on something like workplace transformation or immigration in the workplace, and you approach it in the way you'd approach an overtime dispute, yes, the legal standard, yes, the remedy, I think you're going to fall flat and you're going to frustrate yourself. Wicked problems require lawyers to become facilitators of ongoing engagement rather than vendors of definitive solutions. So for me, that means bringing different stakeholders to the table, embracing interdisciplinary thinking and being honest with clients that the goal is managing complexity rather than eliminating the problem. For policymakers, I think the lesson is to be suspicious of comprehensive, rigid statutory schemes that assume the problem is fully understood and fully solvable in legislation. What wicked problems actually need is adaptive governance. So frameworks that allow for experimentation, that build in review mechanisms, and that acknowledge we will need to adjust as we learn. South Africa's employment equity framework has actually evolved in this direction over the years. And I think actually that's a great sort of way in which we have addressed this wicked problem. So we're revising targets, we're shifting our focus, and I think that's appropriate. The danger is when government acts as though a new piece of legislation will settle a contested social question once and for all, because it will never be able to do so. And then I think for judges, the insight is perhaps more subtle. Courts are actually quite good at tame problems, right? So that's what the adversarial system is designed for. When it's an interpretive problem in front of them, they can apply established legal criteria to resolve it. But when wicked problems land in courts, judges need to be cautious about treating a particular ruling as a comprehensive solution to a systematic issue. A constitutional court judgment on employment equity can shift the legal landscape significantly, but it cannot by itself resolve the underlying contestation about what transformation means or how it should be achieved. So I think the overarching theme is professional humility, not paralysis, but humility. And I think that's actually a more mature and honest account of what law does than the idea that the right statute will fix everything. We need more conversation. We need more conversations between the judiciary, policymakers, lawyers, and we have to come up with multi-pronged, multidimensional approaches to help us solve some of these wicked problems that exist in our society.
Thanks, Marius. And of course, who we've left out of that is, what is our role as legal educators? What role do we have to play?
If we accept the premise of the wicked problems framework, that some of the most pressing challenges facing society are not technical problems amenable to expert solution, but deeply contested, then I think legal education faces what I would describe as quite a crisis of purpose. We are, for the most part, still training lawyers for a world of tame problems in a world that is increasingly defined by wicked ones. So traditional legal education is built around a particular model of professional competences, as we all know. You learn these rules, you learn how to find the applicable rule for a given set of facts, you learn how to construct arguments, and you learn how to win. And that model has enormous value, and I want to be clear that I'm not dismissing it. The ability to identify a statutory violation, argue a case before the labor court, it's all very important. And legal education has spent generations refining the methods for producing those competencies. But I also think that there are several things that we can do. And I'm going to try to be more than just aspirational here. I think first we have a diagnostic responsibility. Before we can teach students to respond appropriately to wicked problems, we need to teach them to recognize them. And I think quite often the irony is that we teach the same problems to especially our LLB students, and many law schools and faculties do not address, especially at the LLB level, the wicked problems. right? And then secondly, we have a responsibility to cultivate what I call epistemic humility. So legal education at its worst produces a certain kind of professional arrogance, the confidence that if you know the law well enough, you can solve any problem. But that confidence is appropriate and even necessary for tame problems. But it becomes actively harmful when applied to wicked ones. And we see this when sometimes lawyers try to just solve problems such as those related to the gig economy or street vendors or something of that nature. So teaching students that expertise has limits, that acknowledges uncertainty in a mark of professional maturity rather than professional weaknesses. And then I think, again, we need an interdisciplinary response. So we have interdisciplinary responsibility. Wicked problems cannot be understood through legal categories alone. Structural unemployment requires economic literacy. Gender inequality in the workplace requires engagement of sociology, psychology, cultural studies, feminist studies, and the like. Platform work regulation requires understanding of technology and global supply chain. Labor migration, pushes us into the realm of international relations, developmental economics, and human rights. So if we train lawyers who are fluent only in legal discourse, we produce professionals who are systematically unable to understand the full dimensions of the most important problems they will be asked to address. I think that some of them, I can go on, but in my own teaching, I try to live these principles through the way I design assessment and reward genuine intellectual engagement. And sometimes that means awarding students for giving an answer that goes somewhat outside of the boundaries of the law.
Marius, I think hearing you describe all of this and discussing, each kind of stakeholder, it almost sounds like the role of dialogue and, like you've said, social partnership. It just becomes even more important when dealing with these kind of issues. And I think it almost forces lawyers, just when you were describing lawyers, it almost forces lawyers to just constantly recognize the limits of just adversarial approaches. It's supposed to be less about winning, I think, as you've said, and facilitating negotiation more and looking at solutions that are a little bit more adaptive. If we have to apply our labor justice barometer, it's a question we always ask our guests on the podcast, where green signals progress, orange suggests uneven reform, red indicates deeper structural challenges or issues. Now, where would you place labor law's ability to deal with these wicked problems?
Thank you so much, Aisha. And this is probably the question that kept me awake last night the most. So I decided to place it firmly in orange, because red, I think, would suggest that the system is totally broken and that nothing is working. And I don't think that's accurate. South Africa has a genuine, sophisticated labor law architecture. And I think, especially for same problems, the compliance issues, the procedural violations, the wage disputes, the system functions reasonably well. And that's not nothing. On the other end, green would be dangerously optimistic. The system has been designed primarily to handle tame problems. And it often defaults to tame problem thinking when confronted with wicked ones. We keep writing new legislation as though structural unemployment or workplace gender inequality can be regulated away. We measure transformation by counting numbers in an employment equity reports, rather than asking whether the underlying dynamics of exclusion have changed. So, orange, therefore, because the progress is real but deeply uneven. And I think the same problems are being addressed with increasing sophistication. The wicked problems are being approached with tools that were however designed for a different kind of challenge. And until there is wider recognition amongst, as we said, lawyers, judges, policymakers, but also the broad general public, that some of the most important labor justice questions are not legal problems in the traditional sense, we will keep cycling through the same reforms, producing the same disappointing outcomes, and wondering why a system that looks so strong on paper keeps falling short in practice for so many South Africans.
Thanks, Marius. Thanks so much for joining us. It's been incredibly insightful, and certainly in my own teaching and research and law reform contexts, this has given me a lot of food for thought. And of course, we should always think of, in particular, labor law is much more about the process in terms of the social, the economic, the political influences that determine the direction. We need to engage in those in a much more meaningful and mindful way. About what our respective responsibilities and roles can be. So thank you. I've thoroughly enjoyed having you on as a guest, and I hope we can get you back again soon. Thank you.
Thank you so much, Debbie and Aisha, for setting this up. It's been an absolute pleasure and a great honor for me to do this. And I really hope that you have me back on again soon. Thank you very much.
Thanks so much, Marius. For our listeners, Marius's article, Wicked Problems in Labor Law, will be available to read soon, and we will share the link on that on our LinkedIn post and Spotify description. But until then, please feel free to reach out to him and keep track of the work he's doing in labor law. We will leave his contact details in the description. Debbie, I'll see you in the next one.
Thanks, Asha. See you soon.
This podcast is not intended to constitute legal advice.